Hello everyone, it's Aprilia and welcome back to my channel, Turning Back Migrants Boat. What does the International Law of the Sea say? The Home Office has unveiled plans to use turn-back tactics in the English Channel, with the border force compelling small boats carrying migrants to return to French waters. The move is the latest in a series of strict immigration policies by Home Secretary Priti Patel following the introduction of a controversial nationality and borders bill in July that seeks to criminalize arrival in the UK without permission. The practice of turn back or pushback of migrant boat is now not new. Australia, Greece, and Italy have all been criticized for similar policies, with the UN Special Rapporteur on the human rights of migrants calling it a cruel and deadly practice that states must end immediately. More than 13,500 people have crossed the English Channel so far in 2021. The ongoing humanitarian crisis in Afghanistan highlight why people risk their life making dangerous journeys in small, unsafe boats. As the Strait of Dover is the busiest shipping route in the world, pushback could be extremely dangerous. Reports suggest that the UK's turn-back policy is only applicable to sturdier, bigger migrant boats. And in very limited circumstances, the government says it has legal advice that allows it to do so under maritime law. So, is it illegal? It is a fundamental and long-standing obligation of international and maritime law to render assistance to persons in distress at sea. Article 98 of the UN Convention on the Law of the Sea 1982 mandates that every state require its ships to render assistance to any person found at sea in danger of being lost. The convention also places a duty on states to operate an effective search and rescue service and to cooperate with neighboring states. The International Convention for the Safety of Life at Sea and the International Convention on Maritime Search and Rescue also recognize this obligation to assist. Gerald Darmanin, the French Interior Minister, has stated that France would not accept any practice that breaches the law of the sea. Indeed, implementing a blanket turn-back boats policy would be to break international law. The UK government claims it can lawfully utilize this practice in a limited and specific way. Certain boats in particular circumstances, but is yet to confirm how Patel has become the first Home Secretary to establish a legal basis for this. Foreign vessels have a right of innocent passage in a state's territorial sea under Article 17 LOSC. If passage is not innocent, such as when domestic immigrant laws are breached, the states can take necessary steps to prevent passage. For seaworthy vessels, this is generally unproblematic. It may be that the UK government expects to rely on some iteration of this principle. But if a vessel determines and justifies that it is in distress, it can enter the state's territorial sea according to an exception in Article 18 LOSC. The duty to render assistance is also still applicable, even where the state believes that migration offenses have been committed by those in peril. France says that a turn-back policy will negatively impact its Cooperation with the UK. There are no international waters in the Dover Straits, the narrowest part of the channel, which is divided between the UK and French territorial waters. France simply may not permit the UK into their territorial waters if returning migrants by force, triggering a standoff. And then the next is human right. Beyond the law of the sea, when officials start to exercise effective control over another vessel at sea by rescuing or physically towing boats back, human rights obligations come into play. Hirsi Jama v. Italy, a case considered by the European Court of Human Rights, involved Italian authorities' interception of migrants at sea, forcibly returning them to Libya. The court concluded that the applicants were under the continuous and exclusive de jure and de facto control of the Italian authorities. During the transfer, meaning Italy had an obligation to protect their human rights. Human rights at sea expert Sofia Kalani also affirms that people in the territorial waters of state are within its jurisdiction for the purposes of human rights, which the state must respect and protect. Such right would include giving people access to a procedure that determines their refuge status and ensuring that there is no collective expulsion of people. In the Hirsi case, the court held that Italian authorities violated the European Convention on Human Rights by not examining each applicant's individual situation. When officials turn back boats, there is breaching the right and obligation enshrined in international human rights law. The exercising of this right is not affected by any potential migration offenses that may have been committed. There could also be branches of refuge law depending on the circumstances, such as the principle of non-refoulement, which prevent states from forcing asylum seekers and refugees back to a place where they may face persecution. There is no obligation in international law to seek asylum in the first safe country, and there are many reasons why individuals choose not to do so. Political sociologist Lucy Maiblin states that there is virtually no way for refugees to safely and legally travel to the UK due to carriers being fined if they transport individuals without visas and tight control at the UK border in France. People are left feeling that they have no choice but to make risky journeys. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe to the channel. See you in the next video, and bye bye.